The iron gates at Rough Point were supposed to open outward. On the afternoon of October 7, 1966, they did not. Eduardo Tirella stepped out of a rented station wagon and walked toward them with a key. He was 42 years old, an artist, designer, decorator, sometime actor, and the man Doris Duke trusted to shape the private rooms of her enormous life. She remained behind the wheel. They were leaving her Newport estate to meet the president of a local preservation society. The subject was old houses. The future they were driving toward was restoration. Instead, the station wagon moved. It struck Eduardo, carried him through the gates, and crossed the road. By the time the car stopped, the man in front of her was dead, while one of the most powerful women in America had survived with injuries and severe shock. Police called it an accident, and within 5 days, the criminal file was closed. Years later, a civil jury would hear enough evidence to find Doris Duke negligent. Her lawyers would concede that evidence of negligence existed. Eduardo's family would receive a judgment. But no criminal charge would ever be filed. Doris would go on to spend millions preserving historic buildings, including houses in the same city where Eduardo died on his way to discuss preservation. That is the first contradiction, but the second is harder. The official story says, a mechanical mistake became a tragedy. Doris shifted into the wrong gear, or lost control, or pressed the wrong pedal. Later investigators argued that the scene, the damage, and the speed of the inquiry did not fit so simple an explanation. A new witness came forward more than half a century later. Newport police reopened the matter, listened, reviewed what remained, and still concluded that the death was an accident. So this is not a story with a clean confession hidden in a drawer. It is a story about what a file can prove, what money can change without leaving a receipt, and what happens when a dead man's life becomes a footnote in the biography of the woman whose car killed him. 3 things will matter all the way through. They are the gates, the 5 days, and the civil courtroom where Eduardo's future was turned into arithmetic. Subscribe for more cases where the file and the legend do not match. By the end, the question will not be whether Doris Duke was strange, lonely, generous, cruel, or impossibly rich. She was, at different times, all of those things in the eyes of people who knew her. The question is narrower and more serious. Did the official accident ruling come from a complete investigation, or did wealth help decide how quickly the investigation was allowed to end? To understand why that question survived, begin with the place. Rough Point stands at the edge of Newport, Rhode Island, where the Atlantic presses cold air against lawns designed to look effortless. The house is large without being delicate. Stone walls, tall windows, rooms made for art, servants, guests, and the long private hours of someone who could own almost anything except anonymity. The estate had belonged to Doris through her family. Her father, James Buchanan Duke, built a fortune from tobacco and electric power. When he died, Doris was still a girl. Newspapers turned her inheritance into a public character before she had time to form one herself. The phrase followed her for decades, the richest girl in the world. It sounds like freedom. For Doris, it also meant trustees, lawyers, headlines, guarded gates, and adults who could not approach her without the possibility that they wanted something. Wealth did not simply give her rooms. It changed every person who entered them. A friend might also be an employee. An employee might also be a companion. A lover might also be a claimant. A doctor might also be a beneficiary. Even kindness could become difficult to separate from access. Eduardo Tirella entered that world because he could make it beautiful. The Rhode Island Supreme Court later summarized a life that was far larger than the final paragraph usually given to him. Eduardo, also known as Edward or Eddie, had worked as a Hollywood extra, an interior decorator, a landscape architect, a designer of women's hats, and a designer of movie sets. He moved among actors and artists. He knew how to choose a color, place an object, shape a garden, and make expensive people feel that a room understood them. He had done work at Doris Duke's estates in Rhode Island, New Jersey, California, and Hawaii. He helped with the floral design of the Duke Gardens in New Jersey, a grand collection of greenhouse landscapes meant to represent garden traditions from different parts of the world. But by 1966, that work was diminishing. The court record says it had been dwindling, becoming less. That small phrase matters because later accounts placed a disagreement close to the center of the last day. Later accounts say Eduardo wanted to leave Doris's service and return to Hollywood, and that Doris did not want him to go. The surviving official record does not give us a reliable transcript of their private conversation. It does give us the condition around it. One person had the money, the estate, and the car. The other had talent, plans, and a relationship that had become difficult to separate from employment. Late that afternoon, they got into the station wagon at Rough Point. They were not driving to a party. They were not escaping photographers. According to the later court opinion, they were going to meet the president of the Newport Preservation Society and discuss the restoration of early colonial homes in the city. Eduardo's last errand was connected to the work that would later become one of Doris Duke's most praised legacies. That is why the gates are more than scenery. They divided the private estate from the public road. They also divided two versions of Doris Duke. Inside the gates was the woman who could order a room remade, keep a friend near, dismiss a servant, or change a plan without explanation. Outside was the city, the police department, the newspapers, and the law. Eduardo walked to the boundary with the key. Doris stayed inside the car, and then the boundary broke. Long before Rough Point, Doris Duke learned that money could answer almost every practical question and leave the important ones untouched. She was born in New York in November of 1912, the only child of James Buchanan Duke and Nanaline Holt Inman Duke. Her father was already a national figure. His business interests had helped build one of the great American fortunes. The family name was attached to tobacco, power, philanthropy, and the university that would carry it into the future. To the public, Doris arrived inside a story already written. There was the immense fortune, and there was the only daughter. There was the father, old enough to seem like a grandfather. There was also the expectation that every private detail belonged to the newspapers because the numbers were so large. When her father died in 1925, Doris inherited the bulk of an estate worth tens of millions of dollars. Exact valuations changed with markets, trusts, and newspaper exaggeration, but the meaning was clear. She was one of the wealthiest children in the world. A child with that much money does not simply grow up rich. She grows up observed. Her movements became news. Her clothes became news. Her friendships became news. Her marriages would become public trials conducted in headlines. The fortune attracted a permanent circle of guardians, advisors, employees, suitors, relatives, critics, and strangers. who believed that access to Doris might alter their lives. The usual biography calls this a poor little rich girl story. That phrase is too easy. It invites sympathy without asking what power did to her. It invites judgment without asking what fear did to her. Doris could be generous on a scale almost no private person could match. She supported medical research, environmental work, historic preservation, performing arts, and cultural institutions. The foundation that now carries her name says she gave away hundreds of millions of dollars in today's value during her lifetime. She created organizations, funded projects, collected art, preserved land, and used her estates as laboratories for interests that were often serious and ahead of fashion. She could also be controlling, suspicious, impulsive, and cutting. Those are not opposites. They are the pattern of a woman who had learned that giving was one of the few relationships in which she could define every term. A gift could be generous and still establish dependence. A salary could be fair and still make departure feel like betrayal. A house could shelter people and still become a system in which everyone waited for the owner's mood. That system followed Doris through adulthood. She married twice. Neither marriage lasted. She traveled widely, studied cultures with real curiosity, and built collections that reflected more than the decorative taste of an idle heiress. At Shangri-La in Hawaii, Islamic art and architecture became central to a home unlike the standard American mansion. At Duke Farms in New Jersey, gardens and greenhouses became enormous personal projects. At Rough Point, European paintings, furniture, textiles, and objects accumulated inside a house that remained deeply private even when its owner became public legend. Doris did not live one life. She moved among several. In one, she was a patron, and in another, an employer. In another, a collector with a trained eye. In another, a woman surrounded by people, but uncertain which of them would remain if the money disappeared. The uncertainty made loyalty especially valuable to her. That is where Eduardo mattered. He was not simply a decorator hired for one room. He had imagination, social ease, and the ability to move between worlds. He could speak to wealthy clients, actors, craftspeople, gardeners, and household staff. He understood performance without being trapped by it. He knew that a mansion is not just architecture. It is a stage on which the owner tries to become the person she wants visitors to see. For Doris, Eduardo could translate desire into physical space. A color could soften a room. A garden could suggest control over climate and distance, and an object placed under the right light could turn inheritance into taste. That kind of work creates intimacy. A designer learns what a client wants before the client can explain it. He sees private habits. He hears arguments. He knows which chair is never used, which photograph is kept out, which guest is expected, which door remains closed. The richer the client, the more dangerous that knowledge can become, even when no crime is involved. Eduardo's access to Doris was valuable because it was personal. It was also unstable because Doris was both friend and employer. The court record gives only fragments. It tells us his work at her estates was becoming less. It tells us he remained connected closely enough to be driving with her to a preservation meeting on the day he died. It tells us his family and friends saw him as a gifted man whose future might have expanded if he had returned more fully to film, design, or independent work. Later writers filled the gaps with stronger claims. Some described Eduardo as the closest male friend in Doris's life. Some said he intended to leave her employment, and that the two argued about it before the crash. Some went further, presenting the death as the violent end of a relationship built on possession. Those claims cannot all be treated equally. The existence of the relationship is documented. The decline in his work for Doris is documented. The fatal drive is documented. The exact private words before the car moved are not. That distinction is where responsible history begins. It is also where the mystery becomes stronger, not weaker. A fictional story would give us the argument. It would place the perfect sentence in Doris's mouth and the perfect answer in Eduardo's. Real life leaves us with a gate, a damaged car, police conclusions, civil testimony, and people whose memories arrived at different times under different pressures. The missing conversation matters because motive, if there was one, would live there. But motive alone would not prove intent. People argue before accidents. People feel abandoned and still make mechanical mistakes. Powerful people can be genuinely shocked by harm they caused. They can also shape the story afterward, without having planned the event itself. The case is difficult because several possibilities remain open at once. Doris may have made a terrible driving error. She may have accelerated in anger without forming a clear intention to kill. She may have acted deliberately, or the physical scene may have been understood poorly from the beginning, leaving later generations to build certainty from gaps that no longer can be filled. The first investigation had the best chance to separate those possibilities. It had the car and it had the gates. It had Doris before years of legal advice and public retelling. It had witnesses whose memories were fresh. It also had a responsibility that became heavier because the driver was Doris Duke. The question was never whether police should treat her as guilty because she was rich. The question was whether they would investigate her as fully as they would have investigated anyone else. Before the law calculated Eduardo Tirella's value, people who knew him tried to describe it. They called him gifted. They called him a genius in several fields. One witness compared him to Michelangelo. Another remembered a man whose taste and skill could command almost any price if he had treated art like a business. That final condition was the problem. Eduardo could create value more easily than he could keep it. He had moved through Hollywood as an extra and a set designer. He worked with interiors, landscapes, hats, flowers, antiques, and color. He knew famous people, but fame did not turn into stable income. The later court record described 2 California apartments, one in Los Angeles and another near Big Sur. It also described a man who often cooked for himself, could not afford a secretary, and relied on loans from friends. He was not poor in the ordinary sense. He had access, talent, contacts, and clients. But he lived in the difficult space between reputation and security. People might praise his eye, ask for his advice, invite him to dinner, and still delay payment. A wealthy patron could make a year possible. Losing that patron could make the next year uncertain. That is one reason his relationship with Doris cannot be reduced to friendship or employment alone. Doris offered commissions across extraordinary properties: Newport, New Jersey, California, Hawaii. The work allowed Eduardo to move through rooms and landscapes few designers would ever touch. It also tied a large part of his professional identity to one unpredictable client. A patron can open doors no ordinary employer can open, and a patron can also become the door. Eduardo's career had already shown how fragile creative work could be. He had been paid well for set design on a theatrical production in the 1950s, according to testimony later summarized by the Rhode Island Supreme Court. He had worked with a real estate developer as a color coordinator and home layout designer. Friends believed more opportunities were possible. There was talk that Richard Burton and Elizabeth Taylor might want him to design a house in Mexico. Possibility surrounded him, and proof did not. When his family later sued, the courtroom demanded evidence of future earnings. The law did not ask whether Eduardo made rooms unforgettable. It asked what tax returns, checks, receipts, and employment records could show. His gifts had to be converted into a number. His irregular career became a weakness because irregular lives are difficult to price. The family presented calculations reaching into the hundreds of thousands and beyond. The defense presented a much smaller picture based on incomplete recent earnings and expenses. One side showed the future his talent might have produced. The other showed the money he had failed to save. The jury awarded $75,000 with additional interest. That was a civil judgment, not a criminal verdict. It did not decide whether Doris intended anything. It did something colder. It placed a financial estimate on the years Eduardo no longer had. The defense had every legal right to challenge the size of the claim. That is what civil litigation does. Yet the language preserved in the court opinion reveals the second death that often occurs after a person is killed near someone famous. First, the body is lost, and then the biography is argued down. His artistic range became instability, and his generosity became failure to support relatives. His social circle became dining with stars while borrowing from friends, and his freedom became evidence that no dependent had lost income. His unfinished opportunities became speculation. The law did not invent those facts. It arranged them for a purpose. That is important because Doris Duke's fortune also entered the courtroom, but in a different way. The jury knew she had the resources to pay a large judgment. The court noted that there was no doubt about it. Yet her money did not define her worth. It defined her capacity. Eduardo's money, or lack of it, defined his projected value. One life entered as capital, but the other entered as uncertain earnings. That imbalance did not begin in court. It had been present in the station wagon. Doris could lose a designer and hire another. Eduardo could lose a patron and watch several estates, several projects, and a powerful social connection disappear together. If later accounts are right, that he intended to return to Hollywood, the decision was not merely a change of address. It was an attempt to separate his future from Doris's control. We should be careful here. There is a temptation to turn Eduardo into a perfect victim because Doris was so wealthy. The record does not require that. He could be charming, careless with money, ambitious, impractical, and brilliant at the same time. None of those qualities reduce the seriousness of his death. They make him human enough to be more than evidence. He was a bachelor. He had family. He had friends who loaned him money and spoke for his talent. He had built a life among artists and stars, without becoming a star himself. He had done work that survived him in photographs, film, gardens, and rooms, even when his name did not remain attached to it. On the day he died, he was doing something practical. He was helping Doris move from private interest to public preservation. The meeting waiting beyond the gates concerned Newport's early colonial houses. Historic preservation was not yet the polished industry it would become. Old buildings could be neglected, altered, or demolished. Doris had money. Eduardo had design knowledge and the social ability to help turn an heiress's interest into a serious project. The appointment matters because it complicates the image of a useless dependent clinging to a rich woman. Eduardo had a role. He was a connector between taste and action. He understood what Doris wanted to save and how to speak about it to people beyond her estate. Within 2 years of his death, Doris would create the Newport Restoration Foundation. It would acquire and preserve dozens of historic buildings, becoming one of the most important parts of her public legacy. The foundation is real. Its work is real. It should not be dismissed because of what happened at Rough Point. But the timing leaves an uncomfortable shadow. The man killed on the way to discuss preservation did not live to see the preservation organization formed. The woman driving the car became celebrated for the work, and history kept the institution and lost the collaborator. That pattern is common around great fortunes. The patron's name survives on the building. The designer, gardener, assistant, secretary, craftsperson, or companion becomes a line in the archive. Eduardo's death made the pattern sharper because it happened at the literal entrance to Doris's world. He reached the gates first, and he was the one who got out. He was the one who carried the key, and when the car came forward, all of Doris Duke's power followed behind it. The houses explain the relationship better than any surviving photograph. Doris Duke owned places large enough to become separate worlds. Duke Farms in New Jersey spread across thousands of acres. Shangri-La in Honolulu was built around Islamic art, ocean light, courtyards, screens, tile, and carefully controlled views. Falcon Lair in California carried the memory of an earlier Hollywood age. Rough Point in Newport held paintings, tapestries, furniture, and the heavy atmosphere of inherited wealth. Eduardo worked across that geography. A conventional employee reports to one office. Eduardo entered the owner's imagination, wherever the owner carried it. He might deal with a room, a garden, flowers, furniture, color, or an event. The work could shift because Doris's attention shifted. There was no clean boundary between project and companionship. That flexibility was one of Eduardo's strengths. It was also a source of dependence. The person who understands a client's taste becomes difficult to replace. The client may begin to treat availability as loyalty. The worker may begin to accept uncertainty because access itself feels valuable. Years can pass before either person admits that the arrangement no longer serves them equally. By the middle of the 1960s, Eduardo was in his early 40s. The court record suggests his work for Doris had been declining. He had reason to think about what came next. A creative career built around a powerful patron can look successful from the outside while narrowing from within. Every completed room strengthens the patron's world. It does not always strengthen the designer's independent future. Later accounts say Eduardo planned to return to Hollywood and that he told Doris he was leaving her service. That claim appears repeatedly in modern retellings, often as the final trigger. It is plausible. It fits the documented decline in his Duke work. It also comes to us through people reconstructing a private relationship after the only other participant was dead. So hold it with care. We can say Eduardo had an independent life and professional ambitions. We can say the work was becoming less. We can say he and Doris were together in Newport on the final day. We can say later witnesses remembered tension over his departure. We cannot hear the argument ourselves. That missing sound is the first major hole in the file. The next hole concerns the station wagon. Doris had access to several cars, including luxury vehicles. The car at Rough Point that day was rented. Modern investigations identify it as a Dodge station wagon with an automatic transmission. The basic official account says Doris moved into the driver's seat while Eduardo went to unlock the gates. She believed the car was in park. When she started it or shifted, it moved backward. Then, trying to correct the movement, she put it into drive and accelerated forward. A wrong gear can kill. A foot can move from brake to accelerator under panic, and an unfamiliar vehicle can respond differently from a familiar one. Those are ordinary facts, and ordinary facts are often enough to explain tragedy. But the scene was not ordinary. The vehicle did not simply bump Eduardo at walking speed. It carried him through iron gates and across Bellevue Avenue before striking another object. The force became central to later doubts. Investigators who questioned the accident ruling argued that the pattern required more acceleration than Doris's explanation suggested. They pointed to the damage, the route, and the physical position of Eduardo's body. The original police inquiry should have answered those questions while the evidence was fresh. How far did the vehicle travel? What damage appeared on the front and rear? Were tire marks measured? Was the transmission tested? Were the pedals inspected? Could the gates open in the direction described? Where exactly did Eduardo stand? What did Doris say first before the story settled? A modern viewer expects photographs, measurements, mechanical testing, recorded interviews, and a carefully preserved chain of evidence. Police work in 1966 did not always meet modern standards. A fatal crash could be investigated as traffic negligence rather than as a suspicious death. That difference matters. When an ordinary driver kills someone during a confused parking movement, an accident ruling may be reasonable. When the driver and victim had a tense relationship, when the victim may have announced a departure, and when the vehicle moves with enough force to break through gates, the threshold for a deeper inquiry should rise. It should rise again when the driver is one of the richest women in America. Not because wealth proves guilt, because wealth changes the environment around evidence. The police chief may know the family name. The mayor may know the estate. A hospital may expect donations. A newspaper may fear legal pressure. Witnesses may assume the important person will be believed, and officers may become careful in ways that look like courtesy and function like protection. None of those pressures needs to be spoken aloud. No envelope has to change hands. No secret meeting is required. Influence often works through anticipation. People know what might happen if they embarrass someone powerful. They adjust before anyone asks. That is why the 5-day closure matters more than any rumor of a direct payoff. A conspiracy is difficult to prove. A rushed process can be shown. The official conclusion arrived while the scene was still being absorbed by the city. Newspaper accounts presented the death as an accident. Police accepted Doris's explanation. The criminal question narrowed quickly and then disappeared. Eduardo's family did not accept that the matter ended there. They brought a civil case. Civil court operates under a lower standard than criminal court. It can find negligence without finding intent. It can force testimony and documents into a public record even when prosecutors decline to act. That case would eventually become the strongest official evidence that the accident story was not legally clean, and Doris's side conceded there was evidence of her negligence. The jury awarded damages. Yet the civil action focused mainly on the amount of money Eduardo's future was worth. By the time the case reached the Rhode Island Supreme Court, the question was not whether Doris had driven carelessly, it was whether the award was large enough. The criminal question had vanished from the formal record. This is how a case can be both public and buried. The death is known. The lawsuit is known. The rich woman's name draws attention. But the central question is quietly moved out of reach. The court discusses earnings, expenses, discount rates, and future work. The police file remains closed. The public receives a conclusion without seeing the full path that produced it. And the person at the center becomes split in two. Eduardo, the artist, lives in the testimony of friends. Eduardo, the legal claim, lives in tax returns and calculations. Eduardo, the possible victim of a crime, never receives a trial at all. To decide whether that absence is suspicious, we have to return to the final drive and slow it down. October 7th began as an ordinary Friday at the end of the Newport season. The summer crowds had thinned. Large houses that had spent months performing wealth for guests were becoming private again. Staff routines changed. Owners prepared to leave or settle into quieter weeks. Rough Point faced the sea with the confidence of a building that had watched generations arrive and disappear. Doris was 53, and Eduardo was 42. They had years of shared work behind them, and, if later accounts are correct, a difficult separation in front of them. No reliable public record gives a complete schedule for the morning. That absence should stop us from inventing a dramatic breakfast, a raised voice in a particular room, or a final private ultimatum. What survives clearly begins later, when Doris and Eduardo prepared to leave for the preservation meeting. The destination was meaningful. They were to meet the president of the Newport Preservation Society and discuss a plan involving early colonial homes. This was not a distant fantasy. Doris had the resources to purchase buildings. Eduardo had design knowledge. Newport had an urgent preservation problem. The meeting could have been the beginning of work that later became institutional. They climbed into the rented station wagon, and at the entrance to Rough Point, the gates were closed. Eduardo got out to unlock them, and from there, two stories begin. The official story is a sequence of mistakes. Doris believed the vehicle was secure. It moved backward. She tried to stop it. In the confusion, she selected drive and pressed the accelerator instead of the brake. The station wagon surged forward. Eduardo was in its path. The vehicle hit him, broke through the gates, crossed Bellevue Avenue, and came to a stop after striking another object. The later suspicious story is a sequence of decisions. Doris and Eduardo had argued. She did not want him to leave. She moved the car backward to create distance, then accelerated forward toward him. The force was not panic, but intention. The crash scene was softened. Evidence was neglected. The richest woman in the city was protected before the investigation truly began. Neither story can simply be announced as fact. The official story has the support of the original police conclusion and the later Newport Police Review. The suspicious story draws strength from the physical violence of the crash, later witness accounts, questions about police procedure, and the civil finding of negligence. The truth has to be built, claim by claim. Start with what is beyond serious dispute. Doris was driving. Eduardo was outside the vehicle at the gates. The station wagon struck him. It continued through the entrance and across the road. Eduardo died almost immediately from his injuries. Doris survived. Those facts alone created a fatal incident that deserved complete reconstruction. The first people arriving at a scene do more than provide help. They decide what kind of event they believe they have entered. If they see a tragic traffic accident, they protect the road, call medical assistance, and document enough to support that conclusion. If they see a possible intentional killing, every object becomes evidence, and every statement becomes potentially important. The label chosen in the first minutes can control everything that follows, and at rough point, the label became accident. Doris was taken for medical care. She had injuries, though nothing comparable to Eduardo's. Her statement described mechanical confusion. The police accepted it. Later investigative reporting raised questions about whether the car was examined with the rigor the event required. It questioned the documentation of tire marks and damage. It challenged the movement described in the official account. It also reported that police did not preserve a full collection of scene evidence that could later be tested. Those criticisms come from retrospective investigation, not from a criminal finding. They deserve attention because missing evidence cannot be recreated. A transmission can be tested while the vehicle is available, and a bent gate can be measured before repair. A road can be photographed before traffic changes the surface, and a driver's first words can be recorded before lawyers and memory refine them. A witness can be interviewed before fear, loyalty, publicity, and age reshape the story. Once those opportunities pass, later certainty becomes dangerous in both directions, and people who believe Doris was protected may treat every gap as proof of murder. People who believe it was an accident may treat every missing test as irrelevant. The honest position is more demanding. A gap is not proof of intent. A gap is proof that a question was not preserved well enough to answer later. That distinction protects both the dead and the accused. It prevents us from convicting Doris through imagination. It also prevents the official ruling from borrowing confidence from evidence that was never collected. The scene had another complication. Doris was not merely a wealthy visitor passing through Newport. Rough Point made her a local institution. The estate, the family name, and the possibilities of philanthropy were known. In a city built partly around great fortunes, the relationship between public services and private money could be close without being openly corrupt. A police officer did not need to admire Doris to understand her power. A reporter did not need to receive a threat to know that a careless accusation could bring lawyers. A city official did not need to ask for favors to recognize that future gifts might matter. But this does not prove anyone changed evidence. It explains why the process itself had to be unusually transparent. Instead, it became unusually fast. 5 days after Eduardo died, the police investigation was closed, with the conclusion that the death was accidental. 5 days is enough time to take statements and inspect a visible scene. It is not much time to challenge the only surviving participant's account, conduct extensive mechanical analysis, reconstruct a complicated vehicle path, interview every possible witness, review the personal relationship, and test whether anger or separation had created motive. Perhaps officers completed everything they believed necessary. Perhaps the accident explanation appeared so obvious that further work seemed wasteful. Perhaps standards of the time were simply lower. Or perhaps the identity of the driver made the easiest explanation easier to accept. The file does not give us a clean answer. What it gives us is a speed that later became part of the evidence. The 5 days did not prove Doris guilty. They made the official certainty fragile, and almost immediately, actions around the city began adding another layer of suspicion. Published investigations later reported that Doris made significant gifts connected to Newport institutions, including support for the hospital and other local needs. Philanthropy was normal for her. She gave money before the crash and after it. A donation by itself is not a bribe, and treating every gift as corruption would be both careless and unfair. Timing, however, changes how gifts are perceived. When a powerful person gives money near a moment of official scrutiny, the public naturally asks whether generosity and influence have become impossible to separate. There is no surviving receipt marked payment for silence, and there is no criminal judgment finding a payoff. There is a community in which the woman under investigation was also a potential source of extraordinary benefit. That is not proof. It is pressure. And pressure is exactly what a careful investigation is supposed to resist. A closed file can look more certain than it is. The cover carries a conclusion. The pages underneath may contain statements, diagrams, photographs, and signatures. To anyone arriving later, the existence of the file suggests that the event has been processed completely. Questions feel old merely because someone stamped an answer on them. The power of official language is exactly this: accident, case closed, and no further action. Each phrase removes urgency. Each tells the next person that the difficult thinking has already been done. In Eduardo's case, the original investigation became the foundation for every later defense of the accident ruling. Newport police concluded there was no crime. Decades later, when new questions appeared, the department reviewed the matter and reached the same conclusion. That continuity can mean the first conclusion was correct. It can also mean later review was limited by what the first investigation failed to preserve. To see the difference, imagine the strongest possible original inquiry. Investigators would begin without choosing a theory. They would document the station wagon from every side. They would record the position of the gear selector, the condition of the pedals, and any mechanical defect. They would measure the gates, road, wall, and final resting point. They would map damage and debris. They would compare Doris's explanation to the physical route. They would ask whether the vehicle's movements could occur as described. They would interview Doris more than once. Repetition does not prove deception, but truthful memory and rehearsed memory behave differently under detail. They would ask about the relationship with Eduardo. Was he leaving? Had they argued? Who knew? What did staff hear? What plans had he made? Did he have tickets, appointments, correspondence, or packed belongings that supported a departure? They would interview estate employees separately. They would identify anyone near the entrance or road. They would collect medical findings, examine the pattern of injuries, and compare them to the car's movement. They would preserve records so another investigator could test the same conclusion. Nothing in that process assumes murder. It is what the seriousness of the event required, and now compare that ideal to what later investigators said they found. They described a thin inquiry. They questioned whether the scene had been measured and photographed fully. They argued that important physical contradictions were not resolved. They highlighted the quick acceptance of Doris's account and the speed of closure. The Newport Police Department has rejected the conclusion that those problems prove a cover-up. During the later review, the department said the death remained an accident. It found that a new witness was credible as a person reporting a memory, but not that the new account supplied enough evidence to overturn the original determination. That is an important distinction. A witness can be sincere and mistaken. A memory can be genuine and still grow less reliable over 50 years. A person may remember a statement accurately but misunderstand its meaning. Police reviewing an old case must ask not only whether a witness appears honest, but whether the statement can be corroborated by surviving evidence. In this case, much of the physical evidence was gone. The car was gone. The untouched scene was gone. Many participants were dead. The opportunity to ask immediate follow-up questions was gone. The later department therefore faced a strange burden. It was asked to judge the adequacy of an old investigation using a record created by that same investigation. If the original file was complete, the later review could confirm it. If the original file was incomplete, the later review could identify gaps but not necessarily fill them. That is why the modern ruling does not erase the 5-day problem. It answers a different question. The original question was what happened at Rough Point. The later question was, does anything available now justify changing the old conclusion? Those are not the same. A lack of new proof is not proof that the original work was sufficient. It is also not permission to declare murder. The case lives between those limits. This middle ground frustrates audiences because it denies the emotional satisfaction of certainty, yet it is exactly where evidence-driven history has to remain. We can judge the process more firmly than the intention. The process was fast. The civil record established evidence of negligent driving. The relationship supplied a possible source of conflict. Later investigators identified questions that the original inquiry did not settle publicly. The modern review found no basis to reverse the accident conclusion. All of those statements can be true at once. The tension lies in what they mean together. If Doris was merely careless, the 5-day closure spared her a deeper public examination that might still have been justified. If she acted in anger without planning to kill, the quick accident label may have prevented the law from examining a more serious form of responsibility. If she acted deliberately, the lost opportunity is permanent. And if the original police were correct in every important respect, their failure was still one of trust. A case involving immense wealth needed a record strong enough to survive suspicion. Instead, the record left room for suspicion to grow for decades. Money creates that burden, because money can influence without announcing itself. The wealthy often object that they are judged unfairly, simply for being wealthy. Sometimes they are. A dramatic fortune attracts dramatic theories. Doris Duke's later life became surrounded by lawsuits, family conflict, eccentric stories, and accusations. It is easy to place the Rough Point death inside a larger legend and let the legend do the proving. That would be a mistake. Doris's reputation cannot substitute for evidence at the gates, but neither can her philanthropy substitute for innocence. A person may preserve houses and still drive negligently. A person may fund hospitals and still benefit from deference. A person may be lonely and wounded and still be capable of rage. A person may also be accused for decades because a terrible accident happened in the presence of wealth. The job is not to choose the most satisfying character. The job is to test the file. The first test comes from the civil case, because it is the one place where Doris's driving entered an adversarial courtroom and could not be resolved by a police conclusion alone. The lawsuit did not ask whether she was a murderer. It asked whether her conduct caused Eduardo's death through negligence and what the lost life was worth. The answer to the first part was no longer seriously contested by the time the case reached Rhode Island's highest court. There was evidence of her negligence. Doris conceded that point. The fight moved to money. And once it moved there, The case revealed more about power than a criminal trial might have done. Eduardo's sister, Alice Tirella Romano, brought the wrongful death action for herself and the rest of the family. The lawsuit did not begin as a grand public trial of Doris Duke's character. It began with the practical mechanism available when criminal authorities had chosen not to act. A civil claim could compel a response. It could place responsibility before jurors. It could create a record where the closed police file had created an ending. Civil law asks for proof on a balance of probabilities, not beyond a reasonable doubt. It can find that one person's carelessness caused another person's death without deciding that the act was intentional. That lower threshold made the courtroom useful and limited at the same time, and useful because Doris could not rely only on the phrase accident. Limited because negligence leaves the darkest question untouched. The trial was extended. Witnesses described Eduardo's work, habits, contacts, income, expenses, and future prospects. Slides showed his design efforts. A film presented parts of his creative life, including appearances in Hollywood productions. Friends tried to explain why a man who had not built savings could still have been on the edge of larger opportunity. The defense answered with records. Tax returns, canceled checks, receipts, incomplete earnings, business expenses, and debt. The result was not simply an argument over numbers. It was an argument over which version of Eduardo counted as real. The family's version looked forward. It saw the designer who could return to Hollywood, work for wealthy clients, and turn decades of experience into income. The defense version looked backward. It saw the man who spent what he earned, borrowed from friends, failed to make a profit from decorating, and had no dependable pattern that justified an enormous award. Both versions used true material. What made the case so painful was this: potential is real, but it is difficult to prove. Financial disorder is real, but it does not erase potential. The law had to predict the future of a dead artist through the paperwork of an irregular past. Experts offered calculations. Depending on the assumptions, Eduardo's lost future could be valued at a very large amount or a surprisingly small one. A change in projected earnings, expenses, work years, or discount rate transformed the result. The jury chose $75,000, and interest added another $21,000. The family believed the award was too low and asked for a new trial. The request was denied. The issue reached the Rhode Island Supreme Court, which upheld the result in 1973. The published opinion is one of the most important documents in the entire story because it removes several things from dispute. It states that Doris was operating the car. It states that the car struck Eduardo as he tried to unlock the gates. It states that they were leaving to discuss historic restoration. It records the jury's award. It also states that Doris conceded there was evidence of her negligence. That concession does not prove intention. It does destroy any version in which Eduardo's death was a blameless event that simply happened around her. Her driving conduct was legally open to fault. The official police phrase accident therefore needs definition. An accident can still involve negligence. It can still involve a preventable decision. It can still create civil responsibility. It can still be investigated poorly. The word does not mean nobody did anything wrong. It means the law did not establish that the harm was intentional or criminal. That difference is often lost in public memory, and people hear accident and imagine innocence. They hear negligence and imagine a minor mistake. but negligence at the controls of a moving vehicle can carry a human body through iron gates. The legal category may be ordinary. The consequence is not. The civil case also exposed the imbalance in how each life entered the room. Doris's fortune was not on trial as a source of guilt. Jurors were simply assured that she could pay whatever award they considered proper. The opinion even noted that the jury knew her resources were more than adequate. Her wealth sat in the background as capacity. Eduardo's finances were opened line by line because his worth had to be calculated. The defense could point out that he owned a small car, kept 2 modest apartments, had no secretary, made little or no profit from some work, and spent his money. Those facts reduced the projected estate his family had lost. Imagine the emotional position of his relatives. To receive compensation, they had to present him as a future financial success, and to reduce compensation, Doris's lawyers had to present him as a talented financial failure. The woman whose car killed him had employed him for years. Her side knew his irregularities because the relationship had been close. Information gathered through friendship and work could now be used to narrow the legal value of his future. This is not an accusation of improper lawyering. A defense attorney must challenge damages. It is a description of power continuing after death. Doris had the resources to litigate. Eduardo's family had the burden of proving a life that had not yet happened. The Supreme Court found the award reasonable. It emphasized uncertainty. The judges could not know whether Eduardo's future would come up roses, as the opinion put it, or whether artistic success would continue without financial stability. That uncertainty belonged to every 42-year-old person alive. Most people are not forced to prove their remaining decades because a car has removed them. Eduardo was. The award became another official ending. It gave the family a judgment, but not a public answer to the criminal question. It confirmed negligence without explaining the speed of the police closure. It preserved biographical details, but arranged them around earning power. Yet the case also planted a fact that later writers could not ignore. Doris Duke's responsibility was not merely rumor. A jury had found enough to award damages. Her side had conceded evidence of negligence. The law had moved beyond pure accident, even if it had stopped far short of murder. That middle finding should have encouraged a careful public memory. Instead, the story split into 2 extremes. One version treated Doris as a tragic driver, unfairly haunted by gossip, but the other called her a killer who purchased freedom. The civil record supports neither extreme fully. It supports a narrower verdict. Doris caused Eduardo's death through conduct a jury could treat as negligent. Whether that conduct began as confusion, panic, rage, or intention remained outside the judgment. The question survived the courtroom. Then Doris began building the legacy that would make the question even more uncomfortable. In 1968, less than 2 years after Eduardo died, Doris Duke founded the Newport Restoration Foundation. The organization would become one of the strongest arguments for taking her philanthropy seriously. It purchased threatened historic buildings, restored them, and helped preserve a part of Newport that could easily have been lost to demolition or careless redevelopment. Over time, the foundation became responsible for dozens of properties. Its work continues. This is not a decorative footnote. Historic preservation requires money, patience, expertise, and a willingness to maintain buildings after the excitement of rescue has passed. Doris supplied those things on a scale that changed the city. People live in restored houses because she acted. Streets retain their historic character because she acted. Crafts, construction knowledge, and architectural evidence survived because she acted. A weak documentary would use Eduardo's death to erase all of that. A flattering documentary would use all of that to soften Eduardo's death. Neither is honest. The two legacies have to remain beside each other, and on the day of the crash, Doris and Eduardo were leaving to discuss preservation. After the crash, Doris built the institution. Eduardo did not receive the future meeting, the public credit, or a place in the foundation's name. This does not prove the foundation was created from guilt. There is no need to invent a secret motive. Doris had genuine interests in architecture, art, and preservation before the accident. The project was already active enough to place a meeting on the calendar, but the sequence changes the emotional meaning. The work Eduardo was helping advance became one of Doris's lasting achievements. His death became something the biography could move past on the way to that achievement. Great fortunes are skilled at absorbing people. A designer shapes a room, and visitors praise the collector whose name is on the door. A gardener shapes a landscape, and the donor receives the plaque. Eduardo Tirella arranged rooms across 4 of Doris's estates, and visitors who walk through Rough Point today do not hear his name. Eduardo's place in Doris's preservation story should not be exaggerated. We cannot claim he designed the later foundation or directed its acquisitions. The evidence does not support that. His place is more precise. He was with her at the beginning of a documented preservation discussion. He died while opening the gates on the way to it. That fact belongs in the legacy. Rough Point itself later became a museum. Visitors can walk through rooms once closed to almost everyone. They can see paintings, furniture, clothing, decorative arts, and the evidence of Doris's collecting. The house presents a complicated life through objects. Museums often create order from people who were not orderly, and a label explains a painting. A room is assigned a period. A photograph receives a date, and visitors move along a route. The person who lived there becomes understandable because the museum has selected what to show, and Eduardo's death resists that kind of order. The gates remain part of the estate, but the event does not fit comfortably inside a celebration of collecting and preservation. It brings the public road into the private house. It asks whether the same wealth that saved buildings also protected its owner from deeper scrutiny. That question is not an attack on preservation. It is part of understanding patronage. Philanthropy can create genuine public good and still increase private influence. A donor may act from curiosity, responsibility, pleasure, grief, reputation, control, or all of them at once. The buildings do not become less preserved because motives are mixed. The public benefit remains. So does the power created by giving. Doris's gifts made institutions stronger. They also made Doris harder to treat as an ordinary citizen. That difficulty does not require a formal agreement. Imagine a city official considering whether to challenge a benefactor whose future support could restore houses, fund a hospital, or protect jobs. Even if the official acts honestly, the stakes feel different. The donor's identity enters the room before any evidence does. The safest answer is procedure and record everything. Test every claim. Invite outside review and make the path to the conclusion visible. That protects the wealthy person from rumor and the public from favoritism. At Rough Point, the speed and thinness attributed to the original inquiry did the opposite. It allowed every later gift to look suspicious. It allowed every restored house to carry a question it did not deserve. It allowed people to argue that philanthropy was a cover, even when the charitable work had independent roots. A better investigation would have protected Doris's legacy as much as Eduardo's memory, and if the evidence showed an accident, a complete record could have demonstrated it. If the evidence showed more, the law could have acted while action was possible. Instead, uncertainty became permanent. Doris continued living for more than a quarter century after the crash. She traveled, collected, funded, fought, adopted, disinherited, reconciled, employed, and dismissed. Her later years generated their own controversies, especially around the people who gained access to her and the decisions made near her death. Those later controversies often get pulled backward into the Rough Point story. A person who behaved erratically later is assumed to have acted violently earlier. That is not sound reasoning. Character evidence can provide context. It cannot replace scene evidence. Doris's capacity for control may make a conflict over Eduardo's departure believable. Her suspicion may make a cover-up theory emotionally plausible. Her generosity may make the accident explanation emotionally plausible to admirers. None of those impressions tells us which pedal she pressed, why she pressed it, or what she intended in the seconds before impact. The strongest case has to remain at the gates. The strongest defense also has to remain there. Everything after the gates matters only if it helps explain the evidence, the process, or the memory, and the foundation helps explain memory. It shows how quickly a powerful life can move into a new chapter, while the dead person's story remains fixed at the last scene. Doris became a preservationist. Eduardo became the designer killed by her car. One identity expanded, the other collapsed. That collapse is why later investigators returned to him. And they were not only asking whether Doris escaped a criminal charge. They were trying to restore the person the official story had reduced. For decades, the Rough Point death remained a durable piece of Doris Duke lore. Biographies mentioned it. Society columns repeated it. Newport residents remembered where it happened. The official conclusion remained accident, while suspicion survived mostly as conversation. Then investigative journalist Peter Lance began treating the event as an unsolved case rather than as a settled anecdote. His work changed the public shape of the story. He interviewed witnesses, studied surviving records, examined the physical scene, and argued that Doris intentionally drove at Eduardo after a confrontation. He also argued that local power and money helped keep the death outside criminal court. These are serious allegations. They are not judicial findings. Lance's reconstruction deserves attention because he did the work the old files seemed to invite. He asked whether the vehicle movements made mechanical sense. He looked at the direction of the gates and the force required to break through them. He searched for witnesses who had not been heard publicly. He examined the timing of police decisions and local donations. He also wrote with the confidence of an advocate who believed he had solved the case. That confidence creates both strength and risk. An advocate notices details a neutral summary may ignore. He also tends to arrange uncertainty toward one conclusion. The more dramatic the theory, the more carefully each supporting claim must be separated from inference. Take the physical reconstruction. The later murder theory argues that Doris first moved backward, then drove forward with force toward Eduardo. The vehicle's path through the gates and across the avenue is presented as evidence of purposeful acceleration. The accident account answers that panic can produce exactly that kind of force. A frightened driver who presses the accelerator while believing it is the brake may continue pressing harder when the vehicle does not stop. Both explanations can fit a violent surge. The missing mechanical documentation makes it difficult to choose between them now. Take the alleged argument. Later witnesses and friends said Eduardo intended to leave Doris's employment and return to California. That gives the story a possible motive. But the record does not preserve a contemporaneous statement from Eduardo describing a threat, nor a reliable recording of the last conversation. Whatever Eddie, as his family called him, told Doris in those last minutes, the motive remains plausible, not proven. Take the donations. Lance and other writers highlighted gifts Doris made in Newport around the period after the crash. The timing can look troubling, especially when police work appears limited. Yet Doris was already a major philanthropist. A gift after an accident may be reputation management, ordinary charity, guilt, influence, or coincidence. Without direct evidence linking money to official action, the donation cannot carry the weight of bribery. The most important part of the later investigation was not a theory, it was a witness. More than 50 years after Eduardo's death, a man named Bob Walker came forward with a memory connected to the events at Rough Point. According to Peter Lance, Walker had been 13 years old in 1966, a paperboy on a bicycle near the corner of Ledge Road, just west of the Duke estate. Newport police took the account seriously enough to review the old case. The department later described the witness as credible, meaning officers did not dismiss him as dishonest or attention-seeking. But credibility is only the first gate. The next gate is corroboration. Could the memory be supported by documents, another witness, physical evidence, or a statement recorded closer to 1966? The department concluded that it could not find new evidence sufficient to change the original accident ruling. For supporters of the murder theory, that result looked like the institution protecting itself. A police department was being asked to admit that an earlier generation of its own officers may have failed in a famous case. Institutional self-protection is possible. For defenders of the accident ruling, the review showed that even a credible new witness could not produce proof of a crime. That is also possible. The later review, therefore, created a partial payoff and a deeper question, and it confirmed that the story was serious enough to reopen. It did not confirm the accusation. It confirmed that a witness existed. It did not restore the missing car, the original scene, or the lost first interviews. It confirmed that doubt was not merely internet gossip, and it did not turn doubt into probable cause. This is where many retellings become dishonest. A sensational version says Newport police reopened the case, therefore Doris was exposed, and a dismissive version says Newport police closed it again, therefore every question was answered. Neither follows. Reopening tells us the new information deserved examination, and closing tells us investigators did not find enough surviving evidence to change the legal conclusion. The decision speaks to what could be proved in the present, not necessarily to what happened in the past. Old cases often fail this way. Time does not simply hide guilt. It destroys the ability to establish innocence with confidence too. A witness dies, and a possible contradiction disappears, and a vehicle is scrapped, and a mechanical explanation becomes theory. A damaged structure is repaired, and measurements become estimates, and a first statement is summarized rather than recorded, and tone vanishes. An officer's choice is remembered as routine when the reasoning was never written down, And after enough years, the case becomes a contest between narratives built on incomplete remains. The responsibility of the documentary is not to pretend those remains are complete, and it is to show which pieces carry weight. The court opinion carries weight because it is a public legal record and fixes core facts, and the police conclusion carries weight because it represents the official criminal judgment. The civil concession of negligence carries weight because Doris's side accepted that evidence existed, and the later investigative reconstruction carries weight where it identifies specific gaps and testable contradictions. The new witness carries weight as a reason for review, but not as independent proof without corroboration. The donations carry limited weight as context for influence, not proof of a transaction, and the argument over Eduardo's departure carries moderate weight as motive context, but remains partly retrospective. When those pieces are arranged honestly, the case does not disappear. It becomes more precise. The strongest accusation is not that we can prove Doris Duke murdered Eduardo Tirella, and we cannot. The strongest accusation is that the original investigation closed too quickly to create the kind of record that could have settled the question. The failure exists even if the accident ruling was correct, and it is a much more dangerous kind of failure than a dramatic conspiracy, because it requires no villainous meeting. It requires only deference, haste, and an official willingness to stop asking. The accident explanation deserves its strongest form. Doris was driving an unfamiliar rented vehicle at the entrance to her own estate. Eduardo stepped out. The car moved in a way she did not expect. She panicked. Under panic, drivers can press the accelerator while believing they are pressing the brake. They can shift into the wrong gear. They can freeze, overcorrect, or continue an action that makes no sense to anyone watching from outside. The violence of the result does not make panic impossible. It may make panic more likely. A person trying to stop a vehicle can press harder on the wrong pedal, precisely because the vehicle is speeding up. The brain interprets the failure to stop as a need for more pressure. By the time the error is recognized, the distance is gone. That mechanism has caused many fatal crashes. Doris also sustained injuries. The vehicle's path did not protect her from danger. If the act were planned, driving through gates and across a public avenue would be an uncontrolled and self-endangering method. It would create witnesses, damage, and a scene impossible to hide. The choice of method therefore argues against calm premeditation. The destination argues against it too. Doris and Eduardo were leaving for a meeting connected to work they shared. If Doris intended to kill him, doing so at the entrance to her own estate, in her own car, immediately before a known appointment, would be irrational. She would become the obvious cause of death. People do act irrationally in rage, but irrationality cannot be assumed simply because it makes a theory possible. The original police saw the scene, heard Doris's account, and concluded accident. Later, Newport officers reviewed the allegations and did not reverse that finding. No prosecutor brought a criminal case. No surviving physical evidence has produced a definitive contradiction. That is the defense, and it is stronger than many sensational videos allow. Now test its limits. An accident explanation must still account for the relationship context. If Eduardo had announced he was leaving, the possibility of anger should have been investigated. The absence of criminal charges is less persuasive when the inquiry itself is questioned. The later police review cannot recreate evidence that was not preserved. and the civil case established enough evidence of negligence that Doris conceded the point. The destination, while innocent on its face, does not eliminate conflict. People argue on the way to work. A known appointment can increase pressure rather than reduce it. Eduardo may have been expected to continue helping with a project, even while planning to separate professionally. The self-endangering method also does not eliminate an impulsive act. A moment of rage is not the same as a planned killing. A driver can accelerate towards someone to frighten, threaten, or stop him, then lose control. Criminal responsibility can exist, even if death was not the original goal. That middle possibility is often missing from the debate. The choice is not only innocent accident or calculated murder. There is a spectrum. At one end, mechanical confusion, then careless operation, panic after an initial error, angry acceleration meant as intimidation, reckless disregard, an impulsive intention to strike. At the far end, a deliberate intention to kill. The original investigation should have considered where the conduct belonged on that spectrum, and the civil case placed it at least within negligence. The police placed it outside crime, and later critics placed it at intentional killing. The surviving evidence does not allow us to fix the exact point with confidence, and this spectrum matters because public language hides it. Accident sounds clean, murder sounds complete, and human behavior is often neither. A wealthy person can benefit from that simplification. If authorities accept accident immediately, every intermediate form of responsibility disappears with it. There is no examination of reckless anger, no challenge to the driver's emotional state, no public testing of whether the fatal movement began as a threat. A critic can also benefit from simplification. If every inconsistency becomes murder, uncertainty is transformed into certainty for dramatic effect. The evidence-driven position is harder to package, but stronger to defend. Doris caused the fatal movement. Negligence was supported in civil court, and possible conflict existed. The original inquiry appears to have closed with unusual speed, and later review did not find enough new evidence to change the accident conclusion. Intent remains unproven. Those 5 statements should remain together. Each of these pieces changes the meaning. Remove any one of them, and the case tilts in a different direction. The documentary's real verdict will have to hold all 5, and before reaching it, one more question needs attention. Why did this case remain so compelling when many negligent driving deaths involving wealthy people were forgotten? Part of the answer is Doris Duke's later reputation. Her life grew more dramatic after Eduardo's death. People around her fought over money, access, adoption, inheritance, and medical decisions. Each controversy made the old suspicion feel more believable. Part is the setting: a mansion, iron gates, a dead designer, and the richest woman in America create a story that looks written before anyone investigates it. But the deepest reason is Eduardo's position. He was close enough to power to know its private rooms, and too weak to control the public story after his death. He was neither stranger nor family, but neither ordinary employee nor equal partner. He was the kind of person whose intimacy could be useful while he lived, and inconvenient once his death raised questions. That position is familiar to anyone who has worked inside a powerful household. It is also why the female audience for stories of domestic power recognizes the danger quickly. The most important conflicts do not always happen in boardrooms. They happen in cars, kitchens, bedrooms, hallways, and at gates, where one person believes the other cannot leave without permission. The official record does not tell us Doris held that belief, and the structure of the relationship makes it possible. The lost conversation prevents us from knowing. And the 5-day investigation failed to build a record strong enough to close the emotional distance between possible and proven. Power rarely arrives at a police station carrying a written order, and more often, it arrives as atmosphere. The name is recognized before the evidence is seen. A superior is called. Language becomes careful. A courtesy is extended. A question that would sound normal to an ordinary suspect begins to feel aggressive. Everyone remains polite, and the result shifts by inches. Which is why corruption is too narrow a word for many failures of equality. Corruption asks for a transaction, and influence can work without one. Newport understood inherited power. The city contained grand summer houses, built by families whose money had shaped railroads, coal, finance, industry, and politics. Public life and private wealth met constantly. Estates employed local people. Owners supported institutions. Charitable gifts could improve hospitals, libraries, churches, museums, and preservation work. The relationship was not simply rich against poor, and a great fortune could be useful to the whole city. That usefulness created caution. Doris Duke was especially significant because she was not only an owner passing through, she had the ability to fund projects others could only discuss. The preservation meeting scheduled on the day of Eduardo's death is proof of that potential. Her later foundation proved the scale of what she could do. Imagine the choices facing local officials after the crash, and a man was dead. The driver was injured and visibly shaken, and her explanation described a terrible mistake. The scene looked like a vehicle accident, not a hidden attack, and the city knew her name. The possibility of challenging her would bring national attention, powerful attorneys, and public conflict. The possibility of accepting the explanation would bring closure, but no one needed to say protect her. The path of least resistance already had a sign, and accident. This is an inference, not a documented meeting. It should remain an inference. Yet it is supported by that evening. Officer Edward Angel, a rookie on street duty, arrived first on Bellevue Avenue. Newport Hospital admitted Doris within the hour. Institutions tend to reduce uncertainty in the direction that creates the least immediate cost. When the uncertain person is powerful, the least costly conclusion often favors that person. A strong procedure is designed to defeat that instinct. Outside investigators could have been invited to Newport. They were not. The station wagon could have been held for independent testing. It was not. A prosecutor could have reviewed the evidence before Chief Joseph Radice declared the death accidental. That review did not happen. Even if every one of those steps ended at accident, the result would carry more authority, and instead, the 5-day closure left the public dependent on trust. Trust is exactly what wealth complicates. The later civil trial did provide adversarial testing, but it came under a different legal question and years after the scene had vanished. By then, the most important evidence had been transformed from objects into memory. Memory favors the powerful too, though not always intentionally. Doris lived. She could tell her version. Her attorneys could refine it. Her public record could absorb it. Eduardo could not answer. His friends and family could speak, but each would be judged for emotion, resentment, money, or loyalty. The dead person's side becomes a collection of partial voices. The surviving powerful person's side becomes a continuous narrative. That imbalance grew as Doris's philanthropy expanded. The more good she accomplished, the easier it became for admirers to treat the old suspicion as an insult. The more eccentric her later life appeared, the easier it became for critics to treat suspicion as proof. Both camps used the woman Doris later became to decide what the driver Doris had done in a few seconds at Rough Point. The evidence remained almost still while the legend grew around it. That is one reason the modern police review mattered. It returned the question to an institution rather than leaving it entirely to biography and rumor. Officers considered the new witness and the old allegations. They did not find a basis to change the ruling. A fair telling must give that conclusion full weight, and it must also ask what the review could actually examine. Could it test the original car? No. Could it remeasure the untouched scene? Number. Could it interview Doris? No. Could it question the first officers while every detail was fresh? No. Could it find enough remaining evidence to bring a criminal case against a dead woman? Apparently not. The review therefore protected a legal standard. It did not restore historical certainty. That difference is not an accusation against the modern officers. It is a limit created in 1966. The first investigation spent the only evidence that could never be replaced, and once spent, no later sincerity could buy it back. This is the midpoint of the story. The meaning now changes. At first, the case appears to ask whether Doris Duke got away with murder. The file cannot answer that strongly enough. The deeper question is whether the system gave itself a fair chance to find out, and on that question, the 5 days become more damaging than any unproven theory. A murder claim can fail for lack of evidence. A process claim can be judged from the absence of work, the speed of closure, the later civil finding, and the permanent gaps. We may never know Doris's intention. We can know that an investigation involving the richest woman in America should have been built to survive doubt. It was not. Doris did not behave like a woman publicly destroyed by the crash, and that observation is emotionally powerful and legally weak. People respond to guilt, shock, and grief in different ways. Some withdraw. Some become more active. Some give money. Some avoid the subject. A person's later life cannot tell us what happened at the moment of impact. What it can show is how completely the event was absorbed. Doris remained one of the most visible private citizens in America. She continued to manage estates, collect art, support institutions, and control a complicated network of employees and advisors. The Newport Restoration Foundation became established. Rough Point remained a residence. The gates were repaired within weeks. The story faded from the front page within days. The city moved forward. Eduardo's family moved forward differently. They had the civil case, the testimony, the public reduction of his career to income and expenses, and an award that could not replace him. They had to watch Doris's name continue expanding, while Eduardo's became attached mainly to the manner of his death. The pattern is common in unequal cases, and the survivor with resources gains new chapters. The dead person remains in the old one. Doris's later controversies made those new chapters unusually crowded. Relationships with employees and companions became intense. Decisions about gifts, adoption, inheritance, and medical care created lawsuits and public accusations. After her death in 1993, disputes over her estate kept her name in court and in the press. Those events invite a simple psychological portrait. Doris, as a woman who needed control, feared abandonment, rewarded loyalty, and punished departure. There is evidence in her life that supports parts of that portrait, and there is also a danger in using it backward. Once a person is labeled controlling, every past disagreement becomes a threat. Once labeled eccentric, every accident becomes suspicious, and once labeled generous, every accusation becomes ingratitude. A documentary can manipulate the verdict merely by choosing which later stories to place beside the crash. The better approach is to use later life only where it reveals a system. Doris's households continued to blur personal and professional boundaries. People could be friends, employees, dependents, advisors, or beneficiaries at the same time. That blurring is relevant because Eduardo occupied the same unstable territory. Access to Doris brought opportunity, and it also made separation difficult. A worker leaving an ordinary job changes employers. A person leaving Doris's world could lose income, housing, travel, social connections, and emotional closeness together. For Doris, the departure could feel larger than a resignation. It could feel like another person choosing the outside of the gates. Again, this is context, and it is not a confession. The emotional logic of a crime can be plausible without the crime being proven. That difference matters most when the accused is dead. Doris cannot answer modern theories. Eduardo cannot answer them either. The only responsible judge left is the evidence. The evidence keeps returning to three official moments. The first is the police closure, the civil concession of negligence, the later police review. The first says accident, and the second says fault. The third says no new basis to change the first, and put together, they create a narrow historical verdict. Doris was not cleared of responsibility, and she was never proved criminally responsible. The process between those points remains open to serious criticism. The problem is that popular storytelling dislikes narrow verdicts. A title promising that a billionaire got away with murder is more immediate. It supplies a villain, a victim, and an answer before the first sentence. The viewer stays to learn how, not whether. That structure can produce attention, and it can also turn investigation into performance. If the evidence does not prove murder, the script begins bending facts toward the title. Negligence becomes intention. Donations become bribes. A credible witness becomes a confirmed eyewitness. A reopened review becomes official proof. Every uncertainty is treated as concealment. The opposite title can be misleading too. Calling the story a tragic accident suggests that controversy is merely gossip. It hides the 5-day closure, the civil finding, and the physical questions. The honest title promise is therefore about the contradiction. Doris Duke's car killed her close friend. Police called it an accident in 5 days, and that is factual. It creates a question without pretending the answer is settled, and it also shifts attention back to process, where the evidence is strongest. Process may sound less dramatic than murder. In practice, it is more unsettling. A murderer is an exceptional person, and a weak investigation is an ordinary institution. The first frightens us because one person may have acted violently. The second frightens us because it shows how power can shape truth without anyone needing to announce a crime. If Doris killed Eduardo intentionally, the weak process helped her, and if she did not, The weak process helped create a permanent accusation she could never fully escape. Either way, the failure injured justice, and that is the consequence the official accident label did not prevent. The file closed, and the case did not. Return to the iron gates, because physical evidence is less impressed by reputation than people are. A gate has hinges, weight, direction, resistance, and damage. A vehicle has gears, pedals, tires, mass, speed, and a path. A body has injuries that can reveal angle and force. When witnesses disagree, those objects can become the most honest participants in the case. The problem is that objects only speak when investigators preserve the language. A photograph can show position, and a measurement can establish distance. A mechanical test can challenge a driver's account. Without those records, later investigators are forced to estimate from repaired structures, old images, newspaper descriptions, and memories. Modern critics of the accident ruling have focused heavily on the car's route. They argue that Doris's explanation required a sequence of movements that should have been tested closely. If the car first moved backward, where did it begin? How far did it travel? What did it strike? When did Doris shift forward? How much distance remained between the station wagon and Eduardo? How much acceleration was required to break the gates and continue across the avenue? Those are not theatrical questions, and they are the case. If the car's path could be recreated comfortably through pedal confusion, the accident explanation grows stronger. If the path required deliberate alignment and sustained acceleration toward Eduardo, the suspicion grows stronger. And if the evidence supports several paths, then the correct verdict is uncertainty. The original officers had the chance to know more, and later investigators did not. That fact changes how every confident reconstruction should be heard. A model built decades later may be intelligent and careful. It is still a model. It rests on assumptions about the vehicle's starting position, gate movement, road condition, driver action, and the location of Eduardo. Change one assumption, and the result can change. The same warning applies to the official account. Because police accepted it early, the account often appears as a neutral fact, rather than one participant's explanation. Doris's description was evidence. It was not the event itself. The distinction is simple, but essential. And the car did not say she confused the pedals. Doris said it, and the police concluded it. The surviving record has not proved another explanation strongly enough to replace it, and that is a defensible legal position. It is not the same as physical certainty. The gates also carry symbolic weight that can distort analysis. They make the scene feel like a Gothic story about a rich woman defending her private kingdom. The image is powerful because it is real, yet symbols can make ordinary mechanics look intentional. A car breaking through iron gates feels like rage, even if the driver was panicking. So separate feeling from force. The force must be measured, and the feeling must be sourced. Later accounts source anger through the reported conflict over Eduardo's plans. The physical theory sources intention through the vehicle path. Neither is complete alone. A motive without matching action proves little. A violent action without motive may still be an accident. Together, they create reasonable suspicion, and reasonable suspicion is the beginning of investigation, not the end of judgment. That may be the clearest description of the original failure. The circumstances supplied enough to ask more questions. The process treated the first explanation as enough to stop. Consider the order. A close associate may be leaving, and a disagreement is later reported. The associate stands in front of the driver's vehicle, and the vehicle accelerates and kills him. The driver is immensely powerful. The scene involves substantial force, and the inquiry closes within 5 days. No single item proves a crime. The combination justified caution. A good investigator would try to disprove the accident account and the intentional account with equal energy. Could the transmission behave as Doris described? Could the pedal error produce the route? Could an angry driver control that route? Did staff hear conflict? Did Eduardo tell anyone his plans before the trip? Did Doris's first statement change? Did damage support reverse movement before the forward surge? The process should create a map in which wrong theories fail, and the rough point file did not create a public map strong enough for that purpose. As a result, both sides can continue selecting the absences they prefer, and defenders say no physical proof of intention survives. Correct. And critics say no complete physical testing survives to exclude intention. Also correct. The two claims do not cancel. They describe the trap created by early closure. This is why the strongest final conclusion cannot rest on the gates alone, and they are central evidence, but incomplete evidence. The legal record must be added, and the relationship must be added. The timing of closure must be added, and the modern review must be added. Then the case can be judged at the correct level, not beyond reasonable doubt, not as internet certainty, and as historical responsibility. Who had the power to preserve the truth? Who used that power? Who benefited when the questions ended? And who lost the ability to speak before the first week was over? The answer to the last question is the easiest. Eduardo did. The new witness arrived in a world that had already chosen its sides, and one side wanted official confirmation that Doris Duke had escaped justice. The other wanted the old accident ruling left alone, and that is a difficult environment for memory. A witness, speaking after more than half a century, does not simply recall an event. He enters a public argument. Every detail is immediately asked to carry more weight than memory may safely hold. Newport police said they found the witness credible. That word is easy to misunderstand. It does not mean every remembered detail was proved, and it means officers found the account sincere and serious enough to investigate. Detective Jacques Wouveis reviewed the case and concluded that no new evidence changed the original determination. In practical terms, the new testimony did not connect strongly enough to surviving records, physical evidence, or other witnesses to support a different legal finding. That outcome disappointed people who believed reopening meant an arrest was coming, but a reopened case is not a reversed case. It is an invitation to test new information, and the test has several parts. First, opportunity. Was the witness in a position to hear or see what he remembers? Second, timing. Did he tell anyone close to the event, and is that earlier disclosure documented? Third, consistency. Has the account remained stable? Fourth, corroboration. Does anything independent support the key detail? Fifth, materiality. Even if the memory is accurate, does it prove intention or only create suspicion? Sixth, legal survival. Could the evidence be admitted and defended under challenge? A memory may pass the first three and fail the last three, but that does not make the witness a liar. It makes old cases hard. The modern department also had to consider a dead suspect. Doris had been gone for decades. No criminal prosecution could follow. The review, therefore, had historical and institutional value, but limited legal purpose. Officers were being asked to pronounce on an event whose central participant could not answer. That can make a department cautious, and it should. A dead person must not be convicted through publicity simply because trial is impossible, and the same caution should extend to Eduardo. He must not be denied a full historical hearing simply because the first file used the word accident, and the review's balanced meaning is therefore narrow. The new witness strengthened the reason to question the old investigation, and the witness did not supply enough new proof to establish a crime. The department stood by accident, and the weaknesses of the original process remained. This is not a dramatic reversal. It is a layered result, and layered results are often closer to truth. The review also revealed something about public trust. If the original file had been complete, the department could have answered modern questions with measurements, tests, and recorded statements. It could have shown why the vehicle path matched pedal confusion. It could have demonstrated how investigators excluded intentional action. It could have explained the 5-day timetable through work completed rather than authority asserted. Instead, the modern conclusion had to rest partly on the absence of enough evidence to overturn the old one. That is legally understandable. Historically, it is unsatisfying. The burden had shifted. In 1966, the state had the burden to investigate a suspicious fatal event fully. Decades later, critics carried the burden to produce new proof from evidence the state had not preserved, and that shift favored the closed file. Once an official conclusion survives long enough, changing it becomes harder than reaching it was, and the first decision receives institutional protection from time. This does not make the later police dishonest. It makes the early decision enormously important. 5 days created more than a closure, and they created a presumption that lasted more than 50 years. The witness could challenge it, and he could not escape it. The same presumption shaped public biographies. Writers could say police ruled the death accidental and move on. The statement was technically true. The reader rarely learned how quickly the ruling came, what evidence was missing, or how civil negligence later entered the record. Official truth became efficient, and suspicion became complicated. The richer story required more time, more caveats, and more willingness to remain uncertain. That is why Eduardo's name often disappeared from short accounts of Doris's life. His death could be summarized in a sentence. His unanswered questions required a chapter. The purpose of returning to the case is not to force the chapter into a verdict it cannot support. It is to refuse the one sentence. Eduardo was not merely a man accidentally struck at a gate. He was a creative professional in a difficult relationship with an immensely powerful patron. He died through her driving. A civil jury found damages. Her side conceded evidence of negligence. The criminal inquiry ended quickly. Later doubts were serious enough for police review. The review found no basis to change the ruling. That complete paragraph is the honest record, and anything shorter changes the meaning. The first weekend after the crash shows how an official story takes shape. According to contemporary newspaper reporting later gathered by Peter Lance, Newport police did not immediately question Doris at length. She entered the hospital with facial injuries and shock. The acting state medical examiner became involved in her care and treated an immediate interview as inhumane. Compassion was reasonable, and delay had a cost. A driver in shock may be medically unable to answer questions. Investigators still need to preserve the earliest possible account. The longer a person waits, the more time exists for memory to settle, for advisors to arrive, and for a confused event to become a coherent story. Doris was first questioned at Rough Point 2 days after the crash, in her bedroom with her attorney and business manager present. Lance reported that the surviving police file contained only a brief set of questions from that first interview. The setting matters, and this was not a police room. It was Doris's room. Her lawyer was there, and her manager was there. The officers had entered her environment to ask about a death caused by her driving. That does not make the statement false. It does show the imbalance of control. An ordinary driver in a fatal event might expect formal questioning, detailed follow-up, mechanical examination, and little ability to arrange the atmosphere. Doris received a bedside interview inside her estate. The first public closure came quickly. The police chief described the event as an unfortunate accident and announced the case closed. The state attorney general reportedly expressed dissatisfaction with the weekend investigation, and the chief then said the inquiry remained open. Within days, however, the accident conclusion stood. This sequence is more important than the later rumor that everyone in Newport had been bought, and it shows pressure inside the official process itself. A chief announced certainty, and a higher legal official questioned the work. The language shifted, and the ultimate outcome did not. A careful record would let us see what additional investigation occurred after the criticism, what new interviews were taken, what tests were completed, which earlier assumptions were challenged. Why did the final conclusion survive? Without a transparent answer, the brief reopening can look procedural rather than substantive, and the first weekend also shaped the press. Newspapers depend heavily on official statements during breaking events. When police call a death an accident, reporters may repeat that conclusion while the public is most attentive. Later doubts struggle against the first headline because the first headline becomes memory. Doris's social position increased that effect. The story was international, but access to the central participant was controlled. Reporters could describe the rich heiress, the station wagon, the dead male friend, and the iron gates. They could not independently reconstruct intention. The official version filled the gap, and this is how 5 days become 50 years. The early phrase is repeated in obituaries. The obituary becomes a source for a biography, and the biography becomes a source for a documentary. The documentary says the case was investigated and ruled accidental. Each repetition adds the appearance of independent confirmation even when all roads lead back to the same small inquiry. The murder theory can create a similar echo. One investigative article makes a strong claim, and later videos cite the article. Other articles cite the videos or repeat the same witnesses, and soon the claim appears widely confirmed when the sources are not independent. This is why source hierarchy matters. The court opinion fixes core facts and the civil result, and contemporary newspapers show what authorities said at the time. The police file, where authenticated and quoted, shows the original inquiry. Later witness interviews add evidence with time-related limits, and modern retellings can guide questions, but cannot vote themselves into proof. Using that hierarchy, the first weekend supports several findings. Doris was not questioned immediately in a rigorous public setting, and her first interview occurred with legal and managerial protection inside Rough Point. The police chief publicly embraced accident very early, and the state attorney general reportedly objected to the quality of the weekend investigation. The final criminal conclusion remained accident. That is enough to justify serious criticism without declaring a hidden conspiracy, and it also changes the emotional image of the gates. When the station wagon crossed them, public authority entered Doris's private world, and during the bedside questioning, public authority adjusted itself to that world. The gates had broken physically, and socially, they were still working. Eduardo's family understood early that memory would have to compete with money. The civil lawsuit was one form of that competition. Testimony was another. Friends and relatives described his ability because the legal system would not assume it. They had to prove that an artist with irregular income still possessed a future. The court opinion preserves their voices in compressed form. A great talent and a connoisseur of antiques. A designer who could have named his price, and a man compared to Michelangelo. The praise may sound excessive when removed from the room where it was spoken. In that room, it had a purpose. The defense had documents showing financial disorder. The family needed language large enough to resist the paperwork. This is the cruel structure of wrongful death law. Love cannot be entered as lost earnings, and taste cannot be discounted to present value. A future room cannot be shown because it was never built, and a career turn cannot be documented because the person died before making it. The family could only offer evidence of possibility, and Doris's side could offer evidence of what had already failed. The jury's award did not declare Eduardo unimportant. It reflected the law's difficulty valuing a creative life. Yet public memory often treats legal money as moral measurement. A modest award can make the death seem modest. A large settlement can make the victim seem important. Eduardo's value was never the number. His value was also not the dramatic usefulness of being killed by Doris Duke, and he deserves to be recovered outside her story. He was born into a family that knew him as Eddie, before rich clients knew him as Eduardo. He entered film and design worlds where identity could be remade through clothes, sets, rooms, and names. He moved among famous people without becoming owned by their fame. He developed several crafts because one craft did not contain him. He could design a hat and understand a landscape, and he could work around cameras and still care about the private arrangement of a room. He could help create fantasy for film and create intimacy for a house. His weakness with money may have been real. It was not rare among artists whose work depends on irregular commissions and social trust. His friends loaned him money because friendship, like talent, does not always fit an accountant's category. His connection to Doris gave him extraordinary work, and it may also have delayed the moment when he could build something independent. If he truly planned to return to California, the decision deserves to be heard as more than a possible motive for Doris. It was Eduardo choosing a future. That future might have failed, and the defense emphasized that possibility. It might also have succeeded, and the family emphasized that one. Death made both impossible to test. The law chose a number, and history should choose a fuller sentence. Eduardo Tirella was a talented, financially unstable, socially connected American designer whose work crossed film, fashion, interiors, gardens, and estates. He was close to Doris Duke for years. On the day he died, he was helping move her preservation interest toward public action. Her car ended his life at the gates of Rough Point. The criminal system called it an accident. The civil system found evidence of fault. The historical system mostly remembered the woman. That last failure is the one still available to correct. We cannot repair the scene. We cannot question Doris, and we cannot restore Eduardo's career. We can refuse to let him remain the male friend in a headline. A person's name is not a solution to a case. It is the beginning of responsibility. Once Eduardo becomes a person again, the 5-day closure feels different, and it is no longer only a question about whether a famous heiress was protected. It is a question about how quickly an artist's unexplored death became acceptable because the surviving story was easier for the city. The city gained a preservation foundation, and the estate kept its owner. The police kept an accident ruling. The newspapers gained a strange headline. Alice Tirella Romano, who had filed the suit, received a civil judgment that could not replace her brother. Eduardo lost every possible future except the one other people would write for him. What would justice have looked like in 1966? Not an automatic arrest, but not a public accusation based on wealth. Not a demand that Doris prove innocence. And justice would have looked like time. Time to examine the station wagon before it disappeared into ordinary use or disposal. Time to photograph and measure the gates before repair. The department needed time to interview every employee separately. Doris's statement had to be compared with the route and damage, and Eduardo's plans had to be investigated without turning gossip into motive. An outside prosecutor could have reviewed the file. The state could have explained its conclusion in enough detail that the public could test it. 5 days may have contained some of that work. The surviving public record does not show enough of it. This matters beyond rough point, because equal justice is not measured only by verdicts. It is measured by the quality of the process offered before a verdict becomes possible. 2 people can receive the same official label and still receive different justice. An ordinary driver may be questioned at a station, have a car impounded, and wait under suspicion. A powerful driver may be questioned in bed, with counsel present, while officials speak publicly about a freak accident. Both cases may end without charges, and the outcomes match. The processes do not, and privilege often hides inside that difference. It does not always buy the final decision. It buys comfort, access, time to prepare, control over setting, and the benefit of a sympathetic first interpretation. Those advantages can shape the evidence before any court sees it. Doris had the right to an attorney, and she had the right to medical care. She had the right not to be convicted by rumor. Eduardo had a public interest in a complete investigation of his death. Those rights were not enemies. A careful process could protect both. Instead, protection became uneven, and Doris's condition was considered. Eduardo's possible conflict with her was not explored publicly with the same care. Doris's account was accepted, and Eduardo's account no longer existed. Doris's future gifts remained valuable to the city, and Eduardo's future had to be estimated by a jury years later. The inequality does not prove intent, and it does prove why procedure had to be stronger than usual. One of the most dangerous habits in historical crime is to judge old investigations entirely by modern tools. Police, in 1966, did not have digital imaging, modern crash software, or today's forensic databases. That limitation should be respected. They did have cameras, they had rulers, and they had mechanics. They had the power to hold a vehicle, and they had the ability to take detailed statements. They had state investigators. They had the ability to avoid declaring a conclusion before those steps were complete. And the criticism is not that they failed to use technology that did not exist. It is that the inquiry, as later described, did not appear to use the available caution demanded by the circumstances. That criticism becomes stronger because the state attorney general reportedly objected at the time. The concern was not invented decades later by filmmakers. Questions arose while the evidence was still fresh. The quick closure, therefore, cannot be excused entirely as a later misunderstanding of old standards, and someone inside the legal system saw a problem. The outcome still hardened into accident. A full inquest could have created public testimony. A grand jury could have heard evidence without requiring a final prosecution. Independent crash analysis could have challenged or confirmed Doris's explanation. Even a formal finding of negligent but non-criminal driving would have shown that the state had examined the middle ground. Instead, the civil jury did that work indirectly, and years later, under a different standard, and with the main physical evidence gone, that delay shifted the burden from public authority to Eduardo's family. They had to hire lawyers, gather records, present witnesses, and defend the value of his future. The state had closed its question. The family had to create another. This is the institutional cost, hidden inside the word accident. It privatized the search for accountability, and the family could seek money. It could not compel the state to reconsider intention, and the civil verdict became a substitute for a public examination it was never designed to provide. By the time the Supreme Court issued its opinion, the case was about business expenses and projected income. The gates appeared in the opening facts and then disappeared behind mathematics. The law had recorded the death, and it had not fully interpreted it. That task fell to history, and history has less power and more freedom. It cannot subpoena, it can compare records, and it cannot convict. It can identify where official confidence exceeds official work. It cannot restore evidence, and it can refuse to hide the absence. The standard this case can still meet is here. Now put the evidence on one table. On the accident side, begin with the original ruling. Newport police saw the immediate scene and concluded that Doris made a driving error. A later department review found no new evidence sufficient to change that conclusion. Pedal confusion and panic are real mechanisms. The use of an unfamiliar rented vehicle adds plausibility. Doris was injured by the same uncontrolled path. The location and timing would have made a planned killing reckless and obvious. Those are meaningful points. On the suspicious side, begin with the force and sequence. The station wagon did not stop at a light contact. It struck Eduardo, broke the entrance, crossed the avenue, and continued. Later investigators argued that physical details did not fit the simple account. Eduardo may have been preparing to leave Doris's service. Staff and friends were later said to have known about conflict. Doris's first detailed questioning was delayed and conducted in the protected setting of her bedroom. The police chief publicly embraced accident very quickly. The state attorney general reportedly criticized the weekend inquiry. Civil litigation established evidence of negligence. Those are meaningful points too, and now remove what cannot carry the verdict. Doris's wealth alone cannot prove guilt. Her later eccentricities cannot prove guilt, and her philanthropy cannot prove innocence. Donations cannot be called bribes without a documented exchange, and a later witness cannot prove intention without corroboration. A missing record cannot be treated as proof that the missing evidence favored one side, and a dramatic reconstruction cannot become fact because it is persuasive. An official ruling cannot become perfect because it is official. After those removals, what remains? A fatal act caused by Doris's driving and a documented professional and personal relationship. possible separation pressure, a rapid criminal conclusion, and a later civil finding consistent with negligence. A public record too thin to end suspicion, and a modern review that could not establish enough new evidence to reverse the old ruling. That remaining structure supports 3 levels of judgment, and the first is legal. No surviving evidence has produced a criminal conviction or an official homicide finding. Doris Duke must not be stated as a murderer as though a court established it. The second is civil. Evidence supported negligence, and her side conceded that point. Eduardo's death was not legally treated as a blameless event. The third is historical. The original investigation did not create sufficient confidence for a case involving this much force, possible conflict, and unequal power. The speed of closure and the missing depth are legitimate subjects of criticism. These levels are compatible, and a person can avoid criminal proof, bear civil fault, and benefit from an inadequate investigation. That may be exactly what happened, and the word benefit needs care. It does not require that Doris ordered anyone to protect her. She benefited if officials accepted her explanation before testing it fully. She benefited if the location and tone of questioning reduced pressure. She benefited if the city treated her as a shaken benefactor rather than as the surviving participant in a suspicious death. She benefited if later uncertainty had to overcome an official conclusion already in place. Privilege can be a result even when it is not a command. Eduardo experienced the reverse. He was unable to supply his account, and his family had to prove his future. His irregular finances reduced the value of the judgment, and his relationship with Doris became known mainly through her biography. His possible departure became motive evidence rather than a life choice, and his creative work became supporting material in a damages case. His name survived because of the woman whose car killed him, and that is the final imbalance. Doris's character was allowed complexity. Eduardo's character was used as calculation, and a fair history restores complexity to both. Doris was not only a monster or a benefactor, she was a person with immense resources, real achievements, difficult relationships, and responsibility for a fatal event whose full meaning was never tested well enough. Eduardo was not only a victim, he was a talented, imperfect, ambitious man whose future was open until a vehicle closed it. The case becomes less simple when both are human. It also becomes more morally clear, and human complexity does not remove institutional duty. The police did not need to know whether Doris was good, and they needed to know what the evidence showed. The city did not need to reject her gifts, and it needed to keep gratitude separate from judgment. The civil court did not need to predict Eduardo perfectly, and it needed to recognize that uncertainty about earnings was not uncertainty about loss. History does not need to convict Doris. It needs to stop pretending the 5-day answer settled every question, and official truth and historical truth are not enemies, but they answer different needs. Official truth must decide whether the state can act. It needs admissible evidence, a legal standard, and a person who can be charged. Historical truth asks what most likely happened, how confidently we can say it, and why the record has the shape it does. In some cases, history can become more certain than law because archives reveal material after a trial ends. In this case, history became less certain because the most useful evidence was not preserved at the beginning. That loss should make the language colder, not weaker, and we do not have to say murder to say the process failed. We do not have to prove a bribe to show that wealth created advantage, and we do not have to deny Doris's philanthropy to refuse its use as character evidence. We do not have to make Eduardo financially successful in imagination to know that the jury was pricing a future no one could see. Precision is not hesitation. It is the final form of respect for a case in which easy confidence caused much of the damage. The police were confident quickly. The critics became confident later, and Eduardo remained dead under both versions. The useful question is therefore not which side speaks with greater force. It is which claim survives contact with the strongest record. The gates are still there. They no longer hold the same damaged shape. Metal can be repaired. Stone can be cleaned. A road can absorb thousands of cars until one violent path becomes invisible. The 5 days are harder to repair. They fixed the official meaning before the evidence had been preserved strongly enough to support it for generations. Once the phrase accident entered the record, every later question had to fight uphill. The burden moved from the state, which once held the scene, to critics working with fragments, and the civil arithmetic remains. $75,000 for the lost future. Additional interest, arguments over earnings, expenses, talent, and financial discipline. A legal recognition that Doris's conduct could be negligent, followed by no public criminal examination of the territory between mistake and intention. Those three things complete the promise. The gates show the force, and the 5 days show the process. The civil courtroom shows the responsibility the criminal file never fully tested. So did Doris Duke murder Eduardo Tirella. The surviving evidence does not justify stating that as fact. The original police called the death accidental. A modern Newport review found no new basis to change that ruling. No court found criminal intent. The passage of time destroyed evidence that might have strengthened either side. Did Doris Duke cause Eduardo Tirella's death? Yes, and that is not disputed. Was there evidence of negligence? Yes, and her side conceded it in civil litigation, and a jury awarded damages. Was the original investigation strong enough to deserve complete confidence? The public record gives serious reason to say no. The inquiry moved quickly. The central participant was questioned under unusually protected conditions. The chief embraced an accident conclusion almost immediately. A state legal official reportedly objected to the early work. Questions about the vehicle, the gates, the relationship, and the physical path were not preserved in a way that could settle later dispute. Did wealth influence that weakness? No document proves a direct order or payment, but wealth shaped the environment. It gave Doris control over access, advisors, setting, reputation, and the city's expectations. It increased the cost of challenging her and the benefit of treating her as a benefactor in shock. The result favored her, whether or not she asked anyone to create it. That is the historical verdict, and criminal intention unproven. Civil fault supported, and institutional failure credible. Privilege present in the process, and Eduardo's erasure undeniable. This verdict will disappoint anyone waiting for a final twist. There is no recovered confession, but no hidden film shows the moment. No new witness can return the car to the driveway, and the last reveal is not that the mystery has been solved. It is that the mystery was made permanent while the evidence was still young, and that consequence belongs to the first investigation. It also belongs to every later retelling that chose certainty over accuracy. Calling Doris a proven murderer gives the audience an answer the record cannot support. Calling the matter a simple accident gives the official process authority it did not earn. Eduardo Tirella was 42. He had designed rooms across 4 of Doris's estates. He had a family who spent years in court over his future. The stronger story remains in the contradiction. A woman known for preserving history was involved in a death whose history was not preserved well enough. A man who helped shape beautiful places died at the boundary of one of them. A city that later benefited from Doris's money had to decide how closely to examine her before those benefits fully arrived. A civil court measured Eduardo's future but could not restore his voice. And a modern police department found a new witness credible while finding too little surviving evidence to change an old conclusion. Every part of the case returns to preservation. Doris preserved houses, and the police failed to preserve certainty. The family preserved a civil record, and investigators preserved doubt. History now has to preserve the limits, and those limits do not protect only Doris. They protect Eduardo from being used as a prop in a sensational accusation. His death deserves more than a title designed to shock. It deserves enough honesty to say where proof stops. The same limits do not protect only the official story. They protect Eduardo from being erased by an easy accident label. His death deserves more than the first explanation, accepted by powerful people in a powerful house. The responsible position is not neutrality between equal stories, and some facts are stronger than others. Doris's responsibility for the vehicle is certain. Negligence is strongly supported, and intentional killing is disputed and unproven. The inadequacy of the surviving investigative record is a serious concern, and the influence of wealth is best understood through advantage and deference, not through an unproved secret transaction. That hierarchy is the difference between suspense and manipulation, and suspense asks what the evidence will allow. Manipulation decides what the audience must believe and bends the evidence until it fits. Eduardo spent his life arranging rooms so objects could be seen in the right relation to one another. Place a chair too far from the table, and the room feels wrong, and hang a painting under the wrong light, and its meaning changes. Remove one object, and the space may lose its balance, and the same is true here. Remove the civil case, and Doris looks blameless, and remove the modern review, and the murder theory looks officially confirmed. Remove the 5-day closure, and suspicion looks irrational. Remove Eduardo's plans and relationship, and motive disappears entirely. Remove the limits of the evidence, and accusation becomes false certainty, and put every piece back, and the room becomes uncomfortable but honest. Doris Duke remains inside it. So does her philanthropy. So does the Newport Restoration Foundation, with more than 70 historic houses under its care, and public sites that continue teaching preservation. So does the fact that she gave away enormous sums to public causes, and good work does not vanish because a person may have received unequal treatment. Unequal treatment does not become acceptable because good work followed. The buildings should stand, and the question should stand beside them. Rough Point became public after Doris's death. Visitors can enter the rooms that once made access a form of power. They can see the collections and the life of the woman the newspapers named the richest girl in the world. The museum offers order, context, beauty, and a route through the house. At the edge of the property, the route meets the gates, and that is where the public story should pause. Not to accuse beyond proof, and not to protect beyond reason. To remember that on October 7th, 1966, Eduardo Tirella stepped out with the key because he expected the gate to open and the day to continue. He had an appointment, and he had work behind him. He may have had a different life ahead of him in California, and he had friends who believed his best work was still possible. He had a family that later stood in court and tried to turn possibility into evidence, and he had seconds between the closed gates and the moving car. Doris had decades afterward, and she used them to create, preserve, collect, give, control, and become more complicated than any single verdict. Eduardo did not receive that privilege of time, and the least an evidence-driven history can do is give him back the complexity the crash removed. Not a perfect artist, and not a helpless dependent, not a nameless friend beneath a famous woman's biography, and a person whose life mattered before it became a case. The gates survived, and the fortune survived, in foundations, museums, land, archives, and restored houses. The accident ruling survived, and the doubt survived too. At Rough Point, the gates still stand. So should the name of the man whose life ended there. Eduardo Tirella.